Now back on the record, the time is 11:37.
So, Mr. Eagan, before we went off the record, you testified that you would not be in favor of recommending an independent fee examiner, correct?
That is correct.
And you understand that part of that person's qualifications would be that they have no connection to any of this, right?
Yes,
And that that person would be reviewing without favor or anything else all of the bills in this case.
I understand that.
Okay. And so can you tell me why, that being the case, you would not want to do that?
There's a cost issue there, and I weighed the risk-reward benefit analysis in my mind and in talking to others outside of this bankruptcy, and I'll tell you that I didn't like the cost benefit, so we said no.
Who did you talk to?
An attorney that we pay outside of the New Orleans bankruptcy team,
Who's that?
Jim Murray, insurance
The-
lawyer.
And so, to be clear, you made the decision, at least on behalf of the Archdiocese, that an independent fee examiner would not be a good idea.
I did.
Now, in the 11th interim fee application, Mr. Eagan, do you know?
Excuse me, are we finished with this?
Yes, sir.
Okay, I just wanted to.
Can you tell me when that issue came up, when you made that decision?
A couple of years ago.
Do you have a month or a year?
No, I can't remember.
And there's no written communication about that issue at all?
There is not.
And you said that you did those calculations in your head?
Well, I probably wrote them on a piece of paper, then discarded it, yes.
And what do you recall?
It was 2 years ago, and I don't remember.
You don't have any recollection of the ballpark of what it may have cost to get an independent fee examiner?
I don't recall.
Did you consider the potential savings?
I did.
And without any written analysis at all, you concluded that that was not a good idea?
I did.
Do you know approximately how many billing entries there are in the 11th interim fee application?
1,500 maybe.
I think there's about 1,900.
I don't have it in front of me, but
Does the Archdiocese, I guess in you in particular, Mr. Eagan, have the time, experience, knowledge, training, or manpower to independently verify 1,900 time entries?
I do.
Okay. You have training for that?
I've been doing financial analysis of businesses most of my life.
I'm talking about attorney fee, specifically bankruptcy attorney's fees.
I don't see a lot of difference in either one.
And you you do review all of the certifications of compliance, correct?
I have, yes.
All right. I want to show you one that I'm not going to attach, and this was attached to the 11th interim fee application, document 2927, and it is the certification of compliance of Laura Ashley. And if you would do me a favor and read section 3 out loud, please.
The whole thing or just the highlighted portion?
The whole thing, please.
I've reviewed the foregoing application, set forth the facts are true and correct to the best of my knowledge, information, and belief. More, I've reviewed Local Rule 2016-1, complex case procedures, and the UST guidelines and submit that application substantially complies with same.
And so that, what she's referring to are the guidelines we just reviewed,
Yes.
correct? And so you knew those guidelines existed, right?
I knew there were guidelines that existed, correct.
Right.
You want this back?
And so, I think we've established that at least some of those guidelines have not been followed, correct?
Yes.
All right. And so when she certifies, or any Jones Walker lawyer certifies, you would expect them to know this better than I do, right?
Yes.
You should know this better than I do, right?
Yes.
And do you know approximately how many certified, or rather certifications like that have been filed with these fee applications?
Fee applications are every 4 months. It's been 48 months, so 12.
The original fee statements that you review, what format do those come to you in?
PDF.
Right, so you get
And-
I'm sorry.
They come in both PDF and leads. Is it leads? Is that the right word? LEDES.
And so you then take those and input them into an Excel spreadsheet.
No, I take the summary and put them in a spreadsheet.
Okay.
Just the total number, the 80% expense and net.
And did you say you do that 2 days a week?
A month.
A month. Do you recall when you received the billing statements for the 11th interim fee application for the first time?
Define the billing statements.
The billing statements that you get prior to those bills becoming part of a fee application?
The statements
Yes, sir.
come once a month. I'm notified when they're in the share file, and then I download those and go through the process previously explained.
And you have, you've reviewed the 3-page challenge log attached to our objection?
Yes,
Have you gone through that and looked at the individual entries?
I have.
And earlier, I think you said that if it just says client or client representative, that's vague, right?
That's vague in the statement that it's applied, correct.
Right. And so, according to the guidelines that we just reviewed, those would not be appropriate fee entries, correct?
Objection calls for a legal conclusion. Don't answer.
Yeah,
You're instructed not to answer that question?
That's what I did. Don't answer.
Okay. Is it your testimony, Mr. Eagan, that every single one of those entries that we challenged is appropriate?
It is, I do believe they are appropriate.
Even the ones where you can't tell who the client or client representative is?
I believe it's appropriate.
Okay. Even though you testified that they're vague and they don't comply with the guidelines, you still are of the opinion that they are appropriate?
I am.
Would you agree with me that Elizabeth Futrell's entries with respect to working on a plan are never specific?
No,
You would disagree with that?
correct.
Okay. Why?
The plan document is a document that Lisa Futrell works on constantly based upon changes in other bankruptcies throughout the United States.
But her fee application entries don't say anything remotely close to that, do they?
I'm satisfied with what they say.
Okay. The question, sir, is not whether you're satisfied. The question is whether they are clear and transparent to anybody reading them in the bankruptcy, and they are not, are they?
I would object to the form of the question. Answer if you can, though.
I believe that they are appropriate, and they do describe what she's doing.
So when she has many, many entries that essentially just say working on plan, you would agree that aside from you, anybody reading that would have no idea what she's doing, correct?
If they understand the complexity of the plan, they probably would agree that that is appropriate.
How about a creditor? How about somebody like James Adams down here?
I can't speak for Mr. Adams.
Okay. Were you aware that that in December of 2023, on the record in bankruptcy court, Mr. Mintz said that the draft plan was not a productive document?
I was there. Read his statement, please.
Sure. He said, and I quote, and so what I'm trying to get at is that we did produce that, and again, I don't think it's a particularly a productive document at the moment, honestly. It doesn't say anything, close quote.
The plan document is a constantly changing document, and as you read that, he was speaking at that point in time.
Right, 3.5 years into the bankruptcy with a whole bunch of entries by Ms. Futrell of working on the plan, correct?
Yes.
And so she had been working all these years on a plan that was not productive and that doesn't say anything according to your lead bankruptcy counsel, correct?
The way I interpret Mr. Mintz's comments was at that moment in time, that plan needed to be updated, which is what Ms. Futrell does.
Are you aware of the fact that activities in a bankruptcy that only take a few seconds are not to be billed?
Yes.
If it takes a negligible amount of time, you don't bill for it, correct?
Yes, sir.
All right. I want you to read for me this one sentence order prepared by Magistrate Judge Mike North.
I'm sorry. Point to which you want me to read.
Right here.
Okay. So he recused himself, yeah.
Okay. And that took you less than 3 seconds, correct?
That particular statement did.
And that's the order. That's the order that's been billed for by Mr. Zarang, by Mr. Wegman. You would agree with me that reading that order, just that order, took you less than 5 seconds.
That sentence took me less than 5 seconds.
Okay. It took me 3, and I think you probably read faster than I do.
Calls for speculation.
But it took, the point being, each one of these orders is exactly the same. And so there's billing for things that take maybe 3 to 5 seconds to read. Fair?
No, the background to that could be much more complicated.
What is the background?
Can't answer that question on that specific statement.
Only Mr. Zarang and Mr. Wegman could answer that, correct?
Can't answer that question either.
Okay. Well, if they entered the time, you don't know the background. If anybody can answer that, it's only them, correct?
Yes.
All right. And so Mr. Zarang billed $150 and Mr. Wegman billed $40. Mr. Wegman billed $40 to do what you just did.
There might be background that you and I, at this moment, are not aware of.
You know, his billing entry says nothing about background.
Correct?
Okay. And so the background certainly wouldn't be clear and transparent to someone like me reading it, would it?
Correct.
All right. Are you aware of the fact that there have been 54 Jones Walker lawyers who have billed into this case?
Yes.
Did you approve of every one of them doing work in this case before they did it?
Generally, yes.
Okay. Do you know who Pauline Harden is?
Yes.
What does she do?
She assists the bankruptcy team in any issues outside of the bankruptcy arena.
What does that, I don't know what that means. Issues outside?
She has a specialty that she deals with, and she advised the bankruptcy team on that specialty.
She's a criminal defense.
Correct.
And do you have any knowledge of whether fees paid to a criminal defense lawyer can be paid out of a debtor's estate?
It depends. I'm not an expert on the law concerning that.
Okay. And I'm not asking for an expert legal opinion. You're the guy in the chair, Mr. Eagan. You're the guy testifying about fees and what people do. And I'm asking you, do you have a belief one way or another about whether criminal defense fees can be paid out of a debtor's estate?
I believe they can to protect the assets of the estate.
Okay. Where did you get that from?
Discussions with attorneys.
And what do you mean when you say protect the assets of the estate?
Exactly what I meant, what I said.
If someone in the Archdiocese theoretically gets arrested, what does that have to do with protecting the estate?
So I don't think that's what we're talking about here.
Okay, well, I'm giving you a hypothetical. And what I'm trying to figure out is in what situation protecting the assets of the estate could be connected to any type of criminal defense legal fees.
We have a presumption of innocence, and to prove our innocence in any situation, whether it's an individual or an entity, we have a right to protect ourselves and defend it.
Are, relative to this fee application or anything that comes beyond it, are any of these criminal defense fees not to Jones Walker being paid out of the debtor's estate?
I said I don't review the ordinary course professionals. So I can't answer whether or not those attorneys in any previous negotiation or lawsuit were paid out of the estate.
Who could answer that for me?
I think those are bills that would go directly to Christopher Countess.
All right, but certainly a CPA doesn't have the authority to authorize payment of those bills, correct?
We have it depends on the size of the invoice. If it's, less than, I forgot the number, quite frankly, a certain amount, he has the authority to approve.
Who approves it above a certain amount?
Depends what invoice it was. So if it's if it's illegal, it would go to Susie outside of the bankruptcy. She does not, again, approve anything within the bankruptcy.
And you really can't answer for me why she doesn't approve anything within the bankruptcy but does approve fees outside of the bankruptcy?
It's two different, in our opinion, it's two different areas of approval.
Who do you mean when you say our opinion?
The opinion of the Finance Council, the Archbishop, and myself.
Do you know who Rudolph Romelli is?
I do.
What's his role in the bankruptcy?
He helped us with the any tax obligation that we might have in the bankruptcy. There could be issues that deal with sales tax or something like that that are minute.
Wayne Zarang has a,
That are or aren't minute.
That are yes, ma'am. I'm sorry.
No, it's good. You're kind of getting low. I
Uh,
don't know why.
Yes.
You getting tired? I mean, you are, I agree, you're dropping your voice.
Oh,
here.
I'm sorry.
if y'all need to break, we can break.
No, I'm just asking the
No, I'm
witness.
okay.
Let's keep going. I'm just,
Yeah.
maybe he's not aware that he's.
Yeah, I'm sorry. I apologize, ma'am.
Mumbling
I will
at
try. I will
times.
try to be more distinct.
In the 11th interim fee application, Wayne Zarang has time billed for things like mediation strategy, right?
Yes.
Has he been in any of the mediation sessions?
No.
Why not?
We did not include him in the mediation sessions.
Okay, explain to me why he is billing for strategy in a mediation that he doesn't attend.
He's a tort lawyer and has input that could be beneficial to us in mediation.
And you're aware that in the 11th interim fee application, we objected to several entries that have to do with the issue of prescription.
Correct.
And Carolyn McCaffrey goes through these bills to ensure that they are UST compliant, correct?
Yes.
All right. And so she's been a lawyer for about 4 years, correct?
I don't know the answer to that.
Okay. On that list I gave
Yeah.
you, it says her
Bar admission.
is 2020,
Okay.
which is she's likely been practicing for fewer than 4 years. And so what you have is an associate reviewing a bunch of partners' billing time, correct?
Correct.
And why was she appointed to do that?
Because she was less expensive than Laura Ashley.
Were you aware, Mr. Eagan, that the subject fee application, the 11th interim fee application record document 2927, Jones Walker has billed for nearly $10,000 relative to the issue of prescription?
Yes.
Why at this point is Jones Walker billing anything relative to prescription?
I'm going to
The
object. That's attorney-client privilege. I instruct the witness not to answer.
So you're not going to let him answer questions about particular fee entries that we've objected to?
I didn't say that. I'm not letting him answer that question.
Would you agree that what Archbishop Amen says to the media and in public regarding this bankruptcy is true information?
yes.
Right? And I want you to take a look.
We'll keep going into it. We'll keep going.
This is from the Section 341 meeting of the creditors on May 29th of 2020, and that same question was asked of Father Patrick Carr on the second page of that document, which is page 61 of the transcript, and it's lines 11 to 18.
I've read it.
Okay. And I want you to take a look. Would you agree that Archbishop Eagan has publicly stated that he got inaccurate advice from Jones Walker?
I don't recall that.
I want you to take a look at what I'm going to attach as 7. As Exhibit 7, a letter dated September 8th of 2023. Take a look at that and tell me if you recognize it.
No, I don't, no.
You don't recognize this?
I don't reckon, doesn't mean I didn't read it before, but I don't recognize it.
Okay. Do you want to?
Yeah, give me a minute. Okay, I've read it.
And so, specifically on the second page, the middle paragraph, would you read aloud that third paragraph on page
So
2?
it starts when?
Yes, sir.
Okay. When we filed for 11 on 2020, I was advised by legal counsel that the Chapter 11 proceedings would only impact our administrative office and not the apostolates, parishes, schools, and ministries of the Archdiocese. This is no longer the case because many external factors now face us, including the fact that the law governing the statute of limitations has changed now to prevent the filing of past abuse claims in civil court.
And so, first, he's referring to prescription there, correct?
He's referring, I think, to two things, but yes, prescription, correct.
Okay. And then the first part of that particular paragraph, and I want to ask you this in terms of what you understood. Was it your understanding, as it was Archbishop Eamon's at the beginning of this bankruptcy, that the apostolates, parishes, schools, and other ministries would be immune from this bankruptcy?
It was our understanding early on, prior to the actual filing, that the channeling injunction would be more easily had and therefore would only affect the debtor.
But a channeling injunction, as you understand it, doesn't require any apostolates to put up any money?
Not necessarily. They could put up insurance proceeds or assign insurance. They could do a lot of things that are not monetarily significant.
The reason I'm asking you this, Mr. Eagan, is because I want to make it clear that it's your position, it's the Archdiocese position, that from at the beginning, before this bankruptcy, and throughout a lot of this bankruptcy, I guess, over 3 years, the Archdiocese understanding was that the parishes and the schools, other ministries, apostolates, were not going to have to pay into this bankruptcy, correct?
At the initial stages of the bankruptcy, that was our understanding.
When did you learn otherwise?
You know, I'd guess, maybe 6 months into the bankruptcy.
Okay. And if you learn that 6 months into the bankruptcy, why did it take Archbishop Eagan another 2 years to tell the parishioners, your parish may have to put up some money?
I don't know.
Is this a good breaking point?
What
Yeah,
time-
whenever
what
y'all
time
want.
is it?
It's 12:06.
Yeah. Can we break now?
Don't want to interrupt.
If you, if you're on,
It's up to y'all.
Now,
No.
are you finished with this?
are you finished with this document?
Yes.
Okay, well then let's take a lunch break.
Okay.
We're now off the record. The time is 12:07. We're now back on the record. The time is 1:02.
So, sorry, Mr. Eagan, we established that some of the entries we're objecting to deal with the issue of prescription. And I want to take a look at some public statements that have been made regarding the issue of prescription. And what I've handed the witness is 3 pages of a 23-page, if you print it to a PDF. And this is a series about George Brignac. And the series was completed in December of 2020 during the pendency of this bankruptcy. Have you seen these stories?
I read some of them, not all of them.
And this one was also, as I understand it, aired in segments on WWL. Do you watch those?
I do not.
Okay, why not?
I'm not a big news guy.
All right.
And
Go ahead.
I have a place in Mississippi, and we don't get WWL.
If you look at the bottom of the second page of that document, which is page 15, and read to yourself the last paragraph.
I've read it.
That's an accurate statement, correct?
I'm not engaged with the proof of claims. It's not my sandbox. So I can't comment on this.
The reason I'm asking you about this, sir, and the reason it appears to be relevant to the issue of prescription is because it's talking, this article during the bankruptcy, about the issue of prescription. And what you read said, and I quote, "Prosecutors' files contain written exchanges between the Archdiocese lawyers and attorneys for at least some of the claimants who settled. Without fail, lawyers representing the church or its insurers took a hard line, arguing that plaintiffs had waited too long and they would be lucky to get anything." And it's your testimony that you haven't seen any of the documents that support that statement.
That is correct.
But you have no reason to dispute it, correct?
That is correct.
Right. Now, if you flip to the next page, which is page 16 of that same story, and go to the third paragraph, it says, and I quote, "An archdiocesan spokesperson this week said positions taken by the church's attorneys don't reflect the beliefs of Eagan and other clerical leaders," unquote. Did I read that correctly?
You did.
Did you know anything about a spokesperson giving a statement to this effect?
No.
Do you know what spokesperson gave that
No.
statement? Does that seem bizarre to you,
Does what seem bizarre?
the statement that I just read?
No, the Archbishop has always indicated that the survivors should be compensated.
Okay, but that's not what I'm talking about here. I'm talking about the fact that somebody on behalf of the Archdiocese said, and I quote, "The church's attorneys don't reflect, or that positions taken by the church's attorneys don't reflect the beliefs of Eagan or other clerical leaders.
So your question, sir?
My question is, does that seem bizarre to you, that his lawyers would be taking positions that he doesn't agree with?
I can't comment. I wasn't involved with this.
I would have to ask Archbishop Eagan, correct?
I didn't say that.
Okay. Who would I ask if I wanted to know if Archbishop Eagan really said that?
I don't know.
But not you.
Correct.
All right. And you understand that statement that I just read deals with the issue of prescription.
No, I'm going to object to the form of the question. I think that's very unclear.
Well, I think the lead into it,
Look, this was written by Ramon Vargas. This is an argumentative position paper.
I think this
It's-
was written. I think this was written by David Hammer and Ramon Vargas
Well,
to be accurate.
both of them, they're advocates. This is an argument.
They're
It's
advocates?
argument. Yes, they're advocates.
Okay, so
This is argumentative.
it's not argumentative.
Yes, it is.
I'm asking him a question.
It's vague.
Okay, let me re-ask it. Are you aware of the fact that at any point during or before this bankruptcy where Archbishop Eagan and other clerical leaders do not support the positions taken by their lawyers?
I'm not aware of that, sir.
But you have no reason to dispute that somebody said that to these journalists on behalf of the Archdiocese.
I've answered the question. May I?
Yes.
I do not know the answer to that. So,
So you have no reason to dispute what's there is correct?
one way or another.
Okay. I'm glad you find this funny, Mr. Vance.
No, I'm reacting to the misleading nature of your recharacterization of the witness's statement. He said he does not know.
Well,
And
listen,
and the way you restated it is very misleading.
So
I'm just kind of surprised a lawyer of your tenure would do that.
what's my tenure? I am asking him,
Your argument.
and this is a deposition, and it's a discovery deposition, and I'm asking the gentleman whether he has any reason to dispute that somebody said that to these journalists. That's all.
He said he doesn't know.
And he said he doesn't, but there's nothing funny or improper.
No, the
And
way
I'm
you
not-
mischaracterized it was improper. I've made my statement for the record.
And so if you assume that statement is correct,
I'm not going to assume anything.
okay, so if I asked you to assume something, you just won't answer the question?
It's hypothetical.
That's correct.
Okay.
You can skip those questions.
Well, I appreciate your advice on how I conduct my deposition, sir.
I'm glad I gave it to you.
But I will ask the questions that I see fit to ask. Thank you. So I want you to take a look at, was that Exhibit 8? Yeah, that would be 8.
Okay.
So wait, the previous article was not 8?
I think it was 8.
That was 8, and this is going to be 9?
Yes, that I think so. I didn't. Let's mark the last one as 8. The WWL article is 8. This one is 9. This is a June 11th of 2021 article by Kimberly Kurth with Fox 8. Have you ever seen this before, sir?
No, sir.
All right. I want you to flip to the second page of that document. And the highlighting got picked up, so I was going to direct you to that anyway. And read to yourself the statement issued on behalf of the Archdiocese.
Both statements or just the one in the middle?
Just the one in the middle is the one I want to ask
Okay,
you about.
go ahead.
Were you aware at any point of that statement?
I don't recall it, no.
Are you aware that this statement was issued the day after the revision to the prescription statute was amended by the legislature in 2021?
No.
So is it fair for me to conclude, and I guess what I would ask you, it would appear to you that at that point in time, the Archdiocese is supporting the new law on prescription, correct?
Based upon this statement,
That they are supporting the new law, correct?
yes.
And so I'm going to ask you to take a look at what I'm going to mark as Exhibit 10. And this is an article from about 3 weeks ago on NOLA.com. Times-Picayune advocate by a journalist by the name of Stephanie Regal. Have you seen this article?
I don't recall.
All right. I'm going to ask you to flip to the second to last page, page 4 of 5, and can you read, please, the highlighted section there?
Eagan said last month that the Archdiocese never opposed the look-back window statute, which was challenged in court by Lafayette, and that it would contribute the same amount of funds towards the settlement regardless of the court's ruling.
And then I would ask you to read.
It makes no difference to us. We think it's important to give everyone something. Whatever number we come up, we will do regardless of what the Supreme Court says.
Do you know when Archbishop Eagan gave these statements to Ms. Regal?
Ms. Regal?
Stephanie Regal.
No, I do not. What date is this?
June 12th of this year, 3 weeks ago.
Yes,
Okay.
I am aware.
Did she come to the Chancery?
No, she came to the residence.
All right. And was it one meeting?
I attended 2 of 3.
So you were present for 2 of 3 meetings. Were you there when Archbishop Eagan said these things?
I was.
Do you agree with these statements?
Yes.
All right. And so those quotes you do know are accurate.
Correct.
All right. So if that is true, that meaning in the 2 statements we looked at, one of June of 2021 and one in June of 2024, that relative to the prescription issue, you would agree that according to Archbishop Eagan, nothing beyond June 14th of 2021 should have been billed relative to the issue of prescription in this bankruptcy.
I disagree with
Why?
that. Because of insurance companies.
Tell me why. I don't understand that.
Insurance companies would take a defense against prescription and say, we're not going to pay any money. So it was a knife that cut both ways.
What insurance company has done that?
I think that's attorney-client.
Wait. Oh. Okay. No, I'm going to object. It's mediation privilege.
Okay. And the...
And I'm instructing the witness not to answer that because it is mediation privilege.
Fair enough. And you understand that at least one of the insurers has filed multiple pleadings into the bankruptcy saying that the Archdiocese has failed to cooperate by sharing information, correct?
Yes, sir.
And Archbishop Eagan is the chairman of the Louisiana Conference of Catholic Bishops, correct?
I don't know, but maybe.
You don't know that?
No, I mean, he's the Archbishop, but that's not an organization I interface with.
He's the metropolitan over the other dioceses in Louisiana, correct?
Yes.
And they are called suffragan dioceses,
Correct.
Okay. Do you know if Archbishop Eagan ever discussed with Bishop Douglas Desitel of Lafayette that the Archdiocese does not oppose the new prescription law?
I do not know that.
Okay. Certainly, as the Metropolitan, he could have told Bishop Desitel not to oppose it, correct?
I would disagree with that.
Well, he certainly could have given him his input, correct?
He could have, yes.
So you know Bishop Desitel fought this thing all the way up to the Supreme Court, correct?
I do.
And you don't know whether Archbishop Eagan said, hey, we're good with the new law, don't do this.
I wasn't present.
All right. So if the ruling doesn't really matter to Archbishop Eagan, do you know why Tom Costanza put in the only red card at the legislature opposing this?
No.
Do you know why the Louisiana Conference of Catholic Bishops filed an amicus brief into the Bienvenue case?
I do not.
Do you know why the Archdiocese filed? The Archdiocese now, I'm talking about in a period well after June of 2021, filed an amicus brief in Luso in the Fifth Circuit opposing the law that he said he supports.
I'm not aware of that.
Okay, I'm telling you that happened, sir, and you're telling me you know nothing of it, right?
That is correct.
Do you know that the Archdiocese billed for that brief in Luso?
No.
You don't remember in reviewing?
No, I don't remember that.
Okay. But if they did, and I'm telling you they did, you would agree with me that that is in stark conflict to what the Archbishop is saying publicly.
Not necessarily.
Why not?
Because of insurance companies.
Okay. What does filing an amicus brief and saying we're against the new law have to do with the insurance issue?
I think the insurance issue is a very complicated and big issue. And much of that is discussed in mediation, and I'm not willing to break that confidence.
Well, the Luso amicus brief was filed before these mediation sessions started, is my understanding.
The insurance discussions started well before that.
Did you review the amicus brief in Luso?
I did not.
Mr. Mintz signed it. Did you know that?
No.
Your lead bankruptcy lawyer signed an amicus brief opposing the law that his client says in public he always supported.
I don't recall that.
If what I'm telling you is true, that is a stark contrast, isn't it?
Not necessarily.
Why not?
Insurance companies.
I don't understand, and I need you to explain to me of your own understanding. Prior to the mediation, between June of 2021 and the mediation, before the mediation started, what was your understanding of why the Archdiocese and Archbishop Eagan through the Louisiana Conference of Catholic Bishops would be opposing a law that he has consistently said that he supports?
The Archbishop has, excuse me, has consistently said that he wants compensation to go to the survivors. That's my answer.
Okay, I understand that, but that's not exactly my question. You understand that, right? That's not the question I'm asking. The question I'm asking is, how does the CEO of the debtor make these unequivocal public statements over a course of 3 years, and during that 3-year period, his lawyers are most certainly opposing the new law? Because that's what happened here.
I can't speak to that.
But you approve those bills, correct?
That is correct.
And so if I ask you the question throughout, including the 11th interim fee application and the 10 that came before it, if I ask you why there is so much money spent on Jones Walker looking at the issue of prescription, what is your response to that?
asked and answered insurance company situations.
Okay, well, I don't think I asked you for the period prior to June of 2020.
The answer would be the same,
Let me
sir.
finish.
I'm sorry. Please.
So I want to get this clear so we're not talking over each other. Your testimony, Mr. Eagan, is that the only reason the Archdiocese has spent money relative to the issue of prescription is for insurance purposes.
My position relative to what I see in discussions with our attorneys relative to prescription deals mostly, almost entirely, with our position with insurance companies.
What does the rest of it deal with?
It would deal with the fact of law as to whether or not the debtor considers all its legal options, at which time, and it never came to this, we would make a decision, but that decision was mitigated by the Archbishop's decision that the survivors should be compensated.
When did he make that decision?
The first day I walked into the chancery to do this bankruptcy.
And so that was still his decision as the chairman of the Louisiana Conference of Catholic Bishops recently when they filed an amicus brief into the Bienvenue case at the Louisiana Supreme Court.
As I stated, I cannot speak to what the Conference of Bishops does.
But Archbishop Eagan can, correct?
I didn't say that.
And as you sit here, is it your testimony that during the course of this bankruptcy, the Archdiocese of New Orleans has not officially opposed the revision to the prescription law?
I am not aware that a decision has ever been made for us to oppose the look-back window.
Based on that testimony, sir, that was 10?
It would be if you
It's
wanted, I just,
All right, I'm sorry,
Not
that,
sure
that
if
was
you-
10.
That was
Okay.
This is 11.
As 11, I am going to present you with an excerpt of record document 814 filed on April 8th of 2021. And I would like for you to read on page 3 of that document what Mr. Mintz wrote.
At the appropriate time, if mediation is not successful, the debtor will object to all or most of its abuse claims because, among other things, the vast majority of them are prescribed on their face.
Did you know that that was filed into the record on
I
behalf
did.
of- You have to let me finish my question, sir. You knew that that was filed into the record in this case over 3 years ago, correct?
Yes.
And so clearly, as I understand it, there has never been anything filed into this record retracting that assertion, has there?
I can't answer that.
You understand what he's writing here is that if we don't settle in mediation, we're going to seek to disallow almost every single claim on the basis of prescription.
Yes.
That's certainly not consistent with Archbishop Eagan saying we don't oppose the law on prescription.
As I read this, it's a strategic and legal position that we took at the time based upon the events at that particular point in time.
But the predicate for my question is correct, that the Archdiocese, through its lawyers, filed into the record a statement that they would try and throw claims out or disallow them based on prescription, and to your knowledge, that position has never been officially amended in the record.
We have indicated publicly that our position is that every survivor should get compensation.
And as we saw earlier, a statement was made that sometimes Archbishop Eagan and others in the hierarchy don't agree with the actions their lawyers are taking, correct?
You have showed that to me, yes, sir.
Is that the case here?
No.
And so Archbishop Eagan would have been fully behind that statement that Mr. Mintz wrote in what I just showed you, correct?
I would share that this is a strategic and legal position at the time that Jones Walker took, and that's my answer.
So it's a strategic and legal position you said that Jones Walker took, correct?
Well, in consultation with the Archdiocesan team.
Was Archbishop Eagan involved in that?
Probably not, probably Susie and I, and certainly Patrick Carr.
Do you know, sir, if Archbishop Eagan has ever reached out to me directly during the course of this bankruptcy?
I have no idea.
Okay. Certainly that should be something his lawyers would know, right?
Excuse me?
That should be something his lawyers should know, correct?
I'm not sure I can answer that.
Okay. And so I think we've established, Mr. Eagan, that you are one of Archbishop Eamon's main advisors, if not his main advisor in this bankruptcy, correct?
I'm one of his advisors.
Okay, and you were advising him relative to this bankruptcy before it was filed, correct?
That is correct.
I want you to take a look, what I'm going to mark as Exhibit 12. Sorry, Pat. And this letter, for the record, is in the bankruptcy record. Have you ever seen that letter before?
I have, yes, sir.
Do you know who wrote this letter?
It was signed by the Archbishop, but I do not know who wrote it. No, sir.
Okay. And I want to ask you at the beginning of paragraph number 2, and for the record, this letter was written on April 28th of 2020, 3 days before this bankruptcy was filed, correct?
Correct.
And the second sentence of the second paragraph says, and I quote, "We have sufficient cash, cash equivalents, and investments to cover 100% of our current liabilities," close quote. Did I read that correctly?
You did?
Is that accurate?
Current liabilities, so at that point in time, yes.
Okay. Is it true now?
No?
All right. When did that become not true?
COVID significantly changed the landscape of the financial sustainability of the entire Archdiocese,
Okay.
as did Ida,
And
Hurricane Ida.
thank you. And we were about 3 months into COVID when this letter was sent to the Vatican, correct?
We were novices as a country at this point in time as to what COVID was.
All right. If you go down to the next paragraph, and the last 2 sentences of that paragraph read, and I quote, "This fund or trust for the settlement of claims will be funded by insurance claims and funds from the Archdiocese. While the majority of these funds will come from our insurance policies, my advisors do estimate that the Archdiocese share of these settlements will be approximately $7 million. Did I read that correct?
You did.
And were you one of the advisors who made this suggestion?
I was.
And where did you, let me rephrase that. How did you come to the conclusion that this bankruptcy would not cost the Archdiocese any more than $7 million?
Based upon the number of cases we knew at the time.
Did you look at any other diocese bankruptcies?
I did.
Was there a single one out there where a diocese paid less than $7 million?
Don't recall.
That would have been something you should have looked at, correct?
I did at the time, I don't recall.
But you can't tell me one that came close to being settled for $7 million or less, correct?
I just indicated to you, I don't recall, and I did look at it at the time.
And so, if you look at the next sentence, Archbishop Eagan cites the USCCB complementary norm to Canon 1277. Do you know what that is?
I know what you know, so, I mean, I'm not a canon law expert.
Do you know if a canon lawyer assisted in drafting this?
I would assume at least this paragraph.
Are you aware that he cited the wrong statute, the wrong
No,
canon?
I am not.
Okay, I'll show it to you. If you flip to the second page at the top, it says, and I quote, "I have sought and received the consent of both the Diocesan Finance Council and the College of Consultors to proceed with the filing for a Chapter 11 reorganization with the U.S. Bankruptcy Court in New Orleans," unquote. Do you know who was on the College of Consultors?
Yeah, so let me see if I can. Father Rodney Berg, Father Ronnie Calkins, Father Peter, who is the Chancellor, Father Frank G. Waugh, Archbishop Eagan. And that's about all I can remember.
So I want you to take a look
Canon law.
at,
Is this an exhibit?
yeah, it's going to be number 13. If you look, Mr. Eagan, at Canon 1292, you would agree with me that that would be the canon
I'm not competent to answer that question.
Okay. Well, does the content of this canon appear to you to talk about alienation of the value of goods?
Yes.
All right. And then it essentially says that if you look at Section 2, the permission of the Holy See is also required for valid alienation of goods whose value exceeds the maximum amount of goods given by the church by vow or goods precious for artistic or historical reasons. Did I read that correct?
You did?
Okay, and then if you go back up to Section 1, it has the language, and I think it's in the second and third line, that this amount is to be determined or defined by the Conference of Bishops for its own region, correct?
That's what it says, yes, sir.
All right. And so that would be the United States, right?
I don't know how to define that.
So here is, as Exhibit 14. As Exhibit 14, referenced by the United States Conference of Catholic Bishops. Have you ever seen this before?
I've never seen this document, no, sir.
Okay, if you go down to the wherefore paragraph on the first page,
Wherefore? Okay, got you.
and so it's my understanding, and if you have a different reading of it, let me know, that this is what Canon 1292, Section 1, what the U.S. Conference of Catholic Bishops' interpretation of that canon is.
Correct.
Okay. And so if you go to paragraph 1, it says, and I quote, "The maximum limit for alienation in any transaction which, according to the norm of law, can worsen the patrimonial condition is $7.5 million for dioceses with Catholic populations of 500,000 persons or more. For other dioceses, the maximum limit is 3.5 million.
That is what it says.
Okay. And so when the Archdiocese of New Orleans filed for bankruptcy, how many were in the Catholic population?
I can't answer that question. I assume it's over 500,000.
You would agree with me that Jones Walker's fees alone are about twice as much as the $7 million referenced in that letter?
Yes.
Okay. And the letter talked about claims, but the canon does not focus on claims. It focuses on how much a diocese will alienate, correct?
That is correct.
Do you know if any of the insurance companies were consulted before this letter was written?
I'm sorry, which letter?
The letter to the
Oh,
Vatican.
The one to the nuncio?
Yes, sir.
Oh, okay, I'm sorry.
Actually, I think the nuncio is copied on it. It's written to the Vatican.
Okay. No, I do not know.
So do you know if prior to sending that letter, any of the insurance companies were consulted about a bankruptcy?
I do not know that.
Okay. Do you know how Archbishop Eagan or anyone came to the conclusion that the insurers would pay the majority of it, the claims?
I'm sorry, restate, please.
Sure. In the letter to the Vatican, it talks about the primary amount of money coming from the insurers, correct?
Yes.
Okay. How would anyone have known that?
Historical settlement information that we received from council.
So you would agree with me that the approximately $40 million in professional fees in this bankruptcy, none of that's been paid by the insurance companies, right?
That is correct.
How much time do you put into handling the Hurricane Ida claims?
Currently, it's different. You know, right after the storm's different than today.
Sure.
So would you restate your question?
Yeah, I guess all of that time was dedicated to the Ida claims during the pendency of the bankruptcy, correct?
Yes, it happened after the filing.
Yeah. And so, like, if you could average it out, what would you say that would be?
That's very difficult for me to do. In terms of today, I really would like you to give me a time frame.
Okay. So I would imagine that there were things that needed to be done immediately. Insurers put on notice, claims made, correct?
Yes.
And so let's talk about the period from August 29th of 2021, which was the date of Hurricane Ida, for like a year beyond that. I would imagine you were pretty busy dealing with Ida claims, correct?
Ida was a significant, time-consuming event.
And so were you putting in more hours at the Archdiocese at the time?
I was working 7 days a week.
All right. And
But I do work from home also. It's not just at the Chancery.
So during that period of time, Mr. Eagan, what would you say, you're working 7 days a week, how many hours are you putting in?
Total, let me see, 65, 70.
All right. And were you involved in handling the Katrina claims?
No, not at all.
All right. I want to
Excuse me, Mr. Trahan, rephrase that question on Katrina.
Were you
and differentiate between insurance and FEMA.
Okay. Did you have any involvement in any way in handling the Katrina claims?
Only the leftover FEMA claims, not the insurance claims.
What do you mean when you say leftover?
Some of the project worksheets are not completed yet.
Did you have involvement in the Ketam case that the government brought against
No, I did
Archdiocese?
not.
I want to talk a little bit about, and I promise you it'll be a little bit about the motion for summary judgment that the Archdiocese filed relative to our objection. Do you know how much time was spent on that motion?
Help me with when it was written. When was filed, excuse me, sir?
It was filed on, do you have it?
Off the record percent.
Is it off the record?
Yes.
We're now off the record. The time is 1:43. We're now back on the record. The time is 1:46.
So you haven't received any bills for this motion yet?
No, sir.
All right. Did Jones Walker get your approval before filing this motion?
Yes.
And as you sit here, you don't know how much time it took to
I do
research,
not.
draft, and write that motion? Does the Archdiocese plan on paying for the work done on that motion?
That's a Jones Walker fee objection. It's my understanding Jones Walker pays for that.
All right. So I want to hit some of the things that are mentioned in this summary judgment.
Can I have a copy so that I can follow you? Thank you.
So two of the bankruptcies that were brought up in comparison were USA Gymnastics and the Boy Scouts, correct?
Yes.
Would you agree that those two bankruptcies are very different from this one?
I would say almost every bankruptcy is different than the other, so yes.
And you know that even at the end of the USA Gymnastics bankruptcy, the total attorney's fees were less than what they are now in this case.
I haven't monitored that.
All right. With respect to the Boy Scout bankruptcy, there were about 80,000 claims. Did you know that?
No.
Okay.
Figured there were a lot, but I didn't know that.
So if that's true, that's about 160 times the claimants in this bankruptcy, right?
That's the math.
All right. Are you aware that there are significant complaints in that document about the manner in which the committee lawyers have billed their time into this case?
Yes.
Okay. Why haven't any of those fees been challenged?
Internally, they have. We're waiting till, as I said earlier this morning, until right before the conclusion of the bankruptcy to negotiate a settlement on what the value of those objections would be.
You do understand that the Archdiocese could do what we on behalf of our clients did here and object as the fee applications come out.
Yes.
Okay. But you've made the decision not to do that.
I don't think it's productive. So yes, I've made that decision.
And it's my understanding that all of the lawyers for the Archdiocese, the Unsecured Creditors Committee, and the Commercial Committee have gotten raises in this case.
Yes.
Do you think that's appropriate?
It was approved by the courts.
All right, but it has to be agreed to, unless it's a motion, it has to be agreed to by the Archdiocese, correct?
Correct.
And there's a section in the summary judgment that complains about the cost of the commercial committee, correct?
That is correct.
All right. You're aware that the Archdiocese fully supported the creation of the commercial committee, correct?
As a result of the TMI objection, that is correct.
All right. You would also agree with me that the cost of the commercial committee and its various experts has now exceeded the total amount that commercial creditors are claiming.
I disagree with that.
Okay. Tell me where I went wrong.
The 2017 bonds are unsecured and are commercial creditors.
Are you talking about the TMI part of it or the Hancock-Whitney?
No, Hancock-Whitney was not at the Archdiocese, the debtor.
All right. You're talking about TMI.
I'm talking about the bonds themselves, that is correct.
And there's already a settlement in principle with respect to that, right?
With certain restrictions on it, correct.
Okay, so if you remove that, the TMI bond debtor portion of this, and you focus solely on the universe of commercial creditors, in that instance, you would agree with me that the fees and costs of this second committee have exceeded what their constituency is claiming as credit.
Object to the form of the question. Answer if you can.
I'd have to look, but probably.
Can we agree at this point, Mr. Eagan, that this commercial committee is not productive? That it's a waste of money?
No.
Why not?
I believe there's a strategic reason to protect the interests of the commercial creditors for themselves, and I believe that it's difficult to take out the bonds from that particular, even though there is an agreement, there's still a unsecured creditor. And it's a very significant part of our liabilities.
So there are also complaints in there about the motion to dismiss that was filed early on in this bankruptcy, right?
Correct.
Okay. And you understand that that motion and what transpired beyond that motion was not filed by me and my co-counsel, right?
I'm not aware of where the genesis of that came from, except from the committee.
Okay. You know the committee filed it,
That is correct.
And you have no evidence that we pushed for that, do you?
I do not.
You don't even know if we opposed it, do you?
I'm not privileged to that information, one way or another.
And there's a statement in the motion for summary judgment that our clients at the time, 4 of them, dominated, that's the word used, the unsecured creditors committee. What evidence do you have of that?
I don't have that. I'm not qualified to answer that question.
Okay. Do you know how your lawyers are qualified to answer that question? Or make that statement, rather, I'm sorry, not answer the question.
Not exactly, no, I do not.
You know of no evidence that Mr. Adams, Mr. Berthelot, Mr. Jackson, and Mr. Johnson dominated the committee in any fashion, do you?
I'm not aware of that, no, sir.
So, as the individual handling this bankruptcy, do you consider yourself to be a very cheap individual?
Yes,
All right. And you took an oath here to tell the truth, did you not?
I did.
And you have a lawsuit pending over an automobile accident, correct?
There was a settlement reached.
It hasn't totally been settled, has it?
That is correct.
Okay.
There
So
is
you
a-
told me there was a settlement reached, and if I would have stopped there, that's where we would have ended it, correct?
Correct.
In fact, your deposition this year had to be taken over 3 different sessions just a few months ago because of your injury and cognitive issues, correct?
My injury issues, yes.
Okay. Are you claiming that you didn't have to do that over 3?
No, I'm claiming I did.
Okay. And part of that was because you claim cognitive impairment, correct?
As a result of medication I was taking, that is correct.
Okay. What medication?
Gabapentin.
Excuse me?
Gabapentin.
Let him finish the question.
I'm sorry.
I want to attach as Exhibit 14, 15, and Globo the 3 volumes of your deposition from your automobile accident case. You did not ask for an accommodation today to take your deposition in sessions, did you?
I did not.
In fact, during your automobile accident deposition, you testified that you could only be deposed for an hour to an hour and a half at a time, right?
At that time, that was correct.
Have you made a significant recovery since
I've
then?
changed medications.
Okay. You would agree with me, sir, that you never, not once, in any of your 3 depositions, attributed your cognitive decline to medication.
It was never asked of me, so that is correct.
And so I want to be very clear here. You're telling me that you always knew that it wasn't your head injury or the accident that caused your cognitive decline, it was medication.
I did not say that. I said at the time, that's what it was.
And so you have no more cognitive impairment?
If I take too much gabapentin, I do.
And so with respect to your cognitive decline and your injuries, is it your testimony that you have made a significant recovery between the time of your last deposition in March and today?
That is correct.
All right.
Except, may I?
Sure.
My neurologist has discovered an inflammation of the bottom of my fusion, which causes pain which is why I'm wearing this now.
And you live by the honor code of Confederate General Robert E. Lee, do you not?
Absolutely. Do you? I mean, he's a good guy.
And you would agree that speaking untruths, especially under oath, might be referred to as unsavory.
A gentleman shall behave as a gentleman.
All right. And you understand what perjury is, don't you?
I do.
All right. Do you remember testifying earlier that you were bound by the mediation privilege and we reviewed Judge Grable's general order regarding procedures for complex Chapter 11 cases?
I do.
And you have not abided by that mediation privilege, have you?
I have.
I want you to take a look at volume 3 of that deposition. And if you would go to page 6,
And
give me a second. Actually, flip to page 23 if you would. Oh, wait. I think I might have handed everyone. This is volume 1.
You guys got different volumes.
Oh, I'm looking at volume 2.
Yeah, with it,
Yeah, this is volume 2.
I'm looking at 3, page 23.
All right, I need a 3 back. Here's a 1.
I've got, I
Here's
think
a
I've
three.
got 3 2s.
They
Is that
have
what you've
3s.
done?
I'm on 23.
I need 3 and a 2.
Here's a 2.
Thank you.
And here's a 2. I got 2 2s.
And so in volume 3, if you go, I'm going to ask you to read to yourself pages 6 and 7.
I've read it.
Okay. And at line 23 of page 6, you say, funny you say that. I was in a mediation yesterday and there was a lawyer. I will not give you his name. He said, are you authorized by the Archbishop to be here today? I said, you want to call him and ask him, that's fine with me. Did I read that correctly?
That is correct.
And who is that lawyer you were talking about?
I don't remember. I don't recall.
You don't?
I just answered it. I don't.
Okay. And so certainly you are relaying a statement a lawyer made and your response about your authority to be involved in that mediation, correct?
I do not look at this as a mediation violation. If it is, I was not cognizant that it would be.
Okay. And so it's your testimony that you don't recall any exchange like that that could have happened between you and one of my co-counsel.
I don't remember who the lawyer was. I testified to that to you.
Are you aware that the only lawyers you named in this car accident deposition are Soren Gisselson and John Danina?
It doesn't matter. I don't remember who this lawyer was.
All right. Now I want you to take a look at page 23. And I want you to read for the record, Mr. Eagan, beginning on page 23 at line 10,
where?
Going through page 24, line 4.
John Perry was mediated with lawyers from Jones Walker. It was a small mediation. It wasn't 30 people. We had a plaintiff's lawyer, 2 attorneys there, a guy named Soren Gisselson and Johnny Denema, and they were talking to me, and they would bring up some points, and I would say to them, this is towards after lunch. So maybe I said, okay, I need to, they just said the wall's blue. I've got to say, I'm not sure it's blue. I think it's pink. And so I would say it was over, and I would like to say something. I had no idea what I wanted to say. And I knew what I mean, because almost embarrassing me, because I don't get that.
And so it is your position that talking about statements and conversations like that within these mediation sessions is not a violation of the mediation privilege.
The context that I was referring to here was my inability to go through a full day of mediation without taking a break.
That's not what you said.
That is how I meant it to be.
Are you saying you didn't say what you meant?
I'm not saying that. I'm saying the context of how I answered this question or this comment was after 2 o'clock, I struggle to, at the time I gave this deposition, to continue answering questions.
All right. And the question I asked you, sir, is it your position that this excerpt from this deposition is not a violation of the mediation privilege?
As I understand it, it is not.
And then I would like you to read at page 95 and specifically lines 8 through 12, if you could read that aloud, please.
I'm dealing with 2 really classy lawyers. It is not this isn't, I'm much more comfortable. I was happy to come here. I'd rather do this than what I did yesterday.
And you referenced the mediation again, correct?
Yeah, I don't remember if mediation was the day before this
It was.
or not. Okay, yeah.
And so again, for a third time, you're referencing the mediation, correct?
I'm referencing that the deposition I was doing was more comfortable to me than what I did the day before.
And inferring that the 2 lawyers you named who happen to be my co-counsel are classless lawyers.
That is in a different section, so
Who are you referring to?
the entire episode the day before.
And so just to be clear, you dislike mediation so much that you would rather give a deposition about your physical condition than be in these mediation sessions?
At that point in time, yes.
Is it different now?
I'm happy to be here today.
You would acknowledge, sir, that none of the 3 lawyers in those depositions or the court reporter have anything whatsoever to do with this bankruptcy?
That is correct.
And certainly not the mediation?
That is correct.
All right. Do you understand that in a mediation, as a general proposition to a mediation, you're supposed to be dealing in good faith?
Correct.
And you're supposed to try and find areas of compromise, correct?
Yes.
And so the statement where you say if Mr. Gisselson and Mr. Danina say the wall is blue, you have to say it's pink. That's what you said, correct?
That is what I said.
Why do you have to do that if you're dealing in good faith?
Because that's my experience in that communication with those guys. So that's my answer.
Your experience is to reflexively disagree with the lawyers who represent the largest contingent of child rape victims in this bankruptcy.
Again, I don't see proof of claims, Mr. Trahan, so I can't tell you whether all of your clients are rape victims. So I do not know the answer to that question.
I'm not asking you, sir, about the content of proof of claims. What I'm asking you
Then I
is...
should have objected to the form of question. Go ahead.
That's okay. What I'm asking you is, you are aware that me and my two co-counsel represent the largest group of survivor creditors in this bankruptcy.
The pro se's are pretty large.
I'm talking about
You said a group, so I'm sorry.
represented group.
I'm sorry. Then yes, correct.
All right. And so, I mean, clearly, if you read that statement and you read it again, not only are you saying you have to reflexively disagree with my co-counsel, but you're then saying you didn't even know why, correct?
That is not what I meant or said, so I disagree with you.
Okay. You said you couldn't come up with a reason and that doesn't happen to you, correct?
I don't know that the relationship with Mr. Gisselson and I started off well,
Why is that?
because the first thing he said is, "I don't trust you."
Okay. And if you're going to reflexively disagree with him, should he trust you?
I believe that if he talked to the lawyers on the other side of the bankruptcy, that is, Stang and Locklord, that I believe that they do trust me.
So, would you agree that reflexively disagreeing when you don't even know why you're disagreeing is the very opposite of good faith?
I would disagree with that.
Why?
I think it's strategy sometimes.
Okay. So, on this, I want to be crystal clear. If you are talking about things that go on in this mediation, things that are said with people you don't really know, on the record, in a transcribed deposition, is it fair to assume that you're also talking to family, friends, and other people?
I do not share any of my work with anyone outside of the circle of the team in the bankruptcy.
I'm talking about statements.
You just asked a question about whether I share with other people,
Yes.
and the answer is no.
You do not share.
I do not.
You do not share the types of things that you said in this deposition with anybody else. Is that your testimony?
I do not, in my opinion, violate the mediation privilege, period.
That's not my question. My question is,
You know, excuse me, Mr. Trader, I do want to object. I mean, I think this is argumentative and completely irrelevant. And it sounds very personal.
Yeah, and
to
I'd
me.
like to take a break because
know.
it's called impeachment,
Okay.
and there's going to be more of it. And so,
Let's take a break.
well, no.
no,
I'm going to finish what I'm saying.
Oh, go ahead. I'm sorry. I didn't mean to interrupt.
That's okay. If he has said things during this deposition that are in conflict with testimony he's given, you know, Pat, that I have every right to confront him with that.
I'm not disagreeing. I just think this is irrelevant. Maybe you will reveal your direction soon enough, and I'll wait.
Okay, fair enough.
Want to go off the record?
Yes. Yeah.
We're now off the record. The time is 2:14. We're now back on the record. The time is 2:28.
So, you testified, Mr. Eagan, that my co-counsel, Mr. Gisselson, said to you, "I don't trust you," correct?
yes, I did,
And when did he say that?
in mediation.
And so you're again...
Wait, no. No, I don't think, no, it wasn't in mediation. Not sure when it was.
When have you been with him other than
In mediation.
Okay. So you just said in front of...
Well, he's a mediation party, you're a mediation party.
Oh, no, I'm not.
Oh, that's right, I'm sorry, then I screwed up.
He violated the mediation privilege by talking about what he said during the mediation, correct?
Objection to the form of the question. Calls for a legal conclusion. Don't answer the question.
Okay. And so you've now made 4 different statements about things that happened in mediation, all with court reporters in the room, correct?
That's your interpretation, not mine.
Well, there were 3 that we looked at in volume 3 of your deposition, and 1 today. That would make 4, correct?
That's the math, yes.
And so what I'm trying to figure out, sir, is these type of statements that maybe you believe them to be violations of the mediation privilege and maybe you don't. You make these kind of statements to people other than lawyers and depositions, correct?
I don't think so. At least I try not to.
And so is it your testimony that the only times you've talked about what's happened in mediation sessions is when there's a court reporter around?
I don't understand that question.
Well, the 4 we've talked about have been when there are 2 different court reporters around.
That's correct.
And so is it your testimony that you only talk about what happens in mediation when there's a court reporter present?
There's information in mediation that's public knowledge that I can talk about. Sale of properties, things that are public in the public domain.
But you know very well that's not what we're talking about here.
I answered the question as best I could.
Now, you've testified that you follow the honor code of Robert E. Lee because he's a good guy, correct?
Robert Lee was the president of Washington and Lee University.
I know very well who he was, but that's not the question I asked you, sir. You testified that he was a good guy, correct?
Yes.
All right. Do you know if Archbishop Eagan subscribes to the theory that Robert E. Lee was a good guy?
I have no clue.
All right. Do you remember testifying that you were cognitively impaired, but not as bad as Joe Biden because at least you know where you are?
I don't recall that.
All right. I'm going to ask you to take a look at volume 2 at page 14.
I don't have volume 2. I have 1 and 3.
I think somebody's got an extra 2.
I got 1.
Which page?
14. You say
What do you want me to read?
I want you to read to yourself starting at page 14, line 3 through 16.
Correct. I read it.
And you did say that, correct?
Correct, concerning names.
Right. And as you sit here, you had, well, I'm talking about the Biden comment you made.
Oh, I'm sorry, because you told me to read to 14, and that's by names. Go ahead.
You compared your cognitive impairment, and said you aren't as bad as Biden because you know where you are, correct?
I said that.
All right. And so you would agree that in a serious job, an important job, it's important not to be cognitively impaired, correct?
I agree with that.
All right. And so You also, in that exchange that you just read, you say that I can tell you that since the date of the accident, that memory recall, especially of names, is more pronounced. You said that, correct?
I did.
And you were not yet on the medication you blame for your cognitive impairment since the time of the accident, correct?
No, that is not correct. I had been. I'd been taking gabapentin before the deposition.
No, I'm talking about the accident.
Oh, okay, I'm sorry. Ask the question again.
You testified that since the date of the accident, your memory recall your cognitive impairment is more pronounced.
No, I didn't say that. I said memory recall, right?
I can't tell you whether or not it's related to the accident. I can tell you since the date of the accident that memory recall, especially of names, is more pronounced.
Yeah, I agree with that.
All right. And you said, I believe, that you attribute any cognitive issues to medication, correct?
I would say that cognitive issues relative to medication are very much pronounced if I take too much gabapentin.
I want you to take a look at volume 3, at page 28, and I want you to read aloud, sir, your testimony starting at line 13 and ending at line 15.
And I know that to the extent of which there is cognitive decline, it's related to the accident. But I'm telling you, this is my impression. I just wanted you to get my thoughts on it. Where do you want me to stop?
You can stop there.
Okay.
And you testified that you knew, to the extent to which there's cognitive decline, it's related to the accident, correct?
Yeah, because the accident caused me to take gabapentin.
Okay. But you didn't start taking that until much later when you saw Dr. Happel, correct?
So I'd have to say I started taking gabapentin when I first went to Happel. That is correct.
You would agree with me that you said nothing about gabapentin when you talked about your cognitive decline. You related it to the car accident, correct?
Yeah, and the car accident caused me to take gabapentin.
You did not say that here, did you?
Correct, but that's exactly what I meant.
And again, nowhere in these 3 volumes of your deposition did you blame any of your cognitive decline on gabapentin.
That wasn't I thought that was a statement.
That was a leading question.
Would you ask it again then? I'm sorry.
Sure. You would agree with me that nowhere in any of these 3 volumes of your deposition did you say my cognitive impairment or cognitive decline is related to gabapentin.
I said it was related to the accident which caused me to take gabapentin. That's what I meant when I said it was related to the accident. It was an unintended, that's it. Sorry.
Your injury and cognitive issues affect your ability to function and manage this bankruptcy, don't they?
I've indicated in my depositions in here that it's in the late afternoon that I have my most problems, not in the morning.
Let me ask the question again. Your injury and cognitive issues affect your ability to function and manage this bankruptcy, don't they?
I disagree with that.
I'm going to ask you to take a look at volume 2. And if you would go to page 25, please.
Yes.
And starting at line 10, the question is, okay, and you're talking about, actually, if you go up to 7, your own lawyer asks, what about any effect on your concentration? You answer, I think I spoke to that. And then the lawyer for State Farm, Mr. Evans, says, okay, and what about your work at the Archdiocese or Magnolia? You ask, what about it? Has it affected it? Yes. Your answer is what?
It takes me longer to do things.
Your answer is, yeah, it takes me longer to do stuff than it did before, correct?
Correct.
And because of your injury or any cognitive issues you claim as a result of this accident, you cannot put in the hours for the Archdiocese that you did before the accident, correct?
At the time of this deposition, that was correct.
So we're talking about a period between your accident in October of 2022, right?
22, that is correct.
And March of 2024, which is about a year and a half. And for that period, it's your testimony for that period, you couldn't put in the hours.
I could not.
And so something changed between March and now that you can pick the hours back up that you were working for the Archdiocese in October of 22 prior to this car wreck?
Dr. Thomas said at the 6-month period, you will have more stamina than you did before.
Okay. And what would the 6-month period have been?
Let me see, November 10th through, I guess that would be April or May of 24.
You claimed in your deposition, Mr. Eagan, that because of cognitive issues caused by your car wreck, that you're no longer as effective in meetings as you used to be, correct?
At the time, I would say that I wasn't as vocal as I used to be.
I want you to take a look at volume 1.
I don't have volume 1. Do you have another copy?
Another bad one.
Thank you.
Page?
And
Is this marked? I mean, I'm a little confused by the...
I'm marking these as 15 in Globo.
Okay, so like volume 3 is part of 15 in Globo?
Yes, sir.
And okay, I got it, thank you.
All right. Now I want you to take a look, sir, at page 77. And I would ask you to please read your testimony from line 4 to line 11 out loud.
I have.
Out loud.
Oh, I'm sorry. I found myself to be fairly quick-witted. I've lost some of that. My preparation prior to the accident and surgery, both I could go confidently into a meeting of any sort without a lot of preparation, and now I require myself to actually type out what I need to say and follow the script.
And so what you're saying there, and correct me if I'm wrong, is that you used to be able to go into a meeting without a script, but at least in March of 2024, this year, you needed a script when you went into a meeting, correct?
That is correct.
Okay. And did that change?
I like that preparation better than before, so I still use it.
Like the bullet points?
Bullet points, yes.
What was in those bullet points?
Which bullet points?
The ones we talked about earlier. You said you had 2-page bullet points.
Oh, it was just, how did you get involved with the bankruptcy? How long have you known the Archbishop? The questions you asked early on.
Do you still script your meetings?
I do.
Okay. But you didn't script anything for this deposition, correct?
I told you what I did earlier.
Okay. But that's not exactly scripting.
That's in my mind it is, yes.
And you also claim that as a result of this car accident, you have trouble remembering who people are, correct?
Names, correct.
Right. Like somebody you see on a weekly basis, you can no longer remember that person's name, correct?
I didn't say that. If I haven't seen somebody in a year, I may not recall their name.
Would you please look at volume 2? Page 15, and I would ask you to read, the question is, has that gotten better with time? And I'd like you to read your answer at line 3.
Yeah, so I don't think so. There was a guy at the Archdiocese that I see every week. He walked in, I had to look at his name tag, so I had not gotten better.
Okay, and that's the opposite of what you just told me.
I don't think so. I don't have dealings with this guy every day. I see him in the hall, and so I didn't remember his name.
And as of March, your memory issues from this accident had not improved at all, had they?
That is correct. Names, so I want to rephrase that, ma'am. The only reference I have to memory would be recalling names of individuals.
All right, I'm going to ask you to look in volume 3 at page 88, please. And so I would ask for you to read to yourself the question starting at page 87, line 21.
Okay.
And then at line 18 of page 88, Mr. Evans asked you, all right, memory issues, improvement, and then what is your response at line 24?
I would say it's not improved.
And that had absolutely nothing to do with the earlier testimony from a different volume about remembering people's names, right?
I disagree with you.
Okay. Show me where in that exchange, anywhere in that exchange, that you're talking about forgetting somebody's name.
Absent the words does not indicate what the moment of my understanding the question was.
Clearly, there's nothing anywhere that you just looked at in that question that limits your memory issues to people's names, correct?
My understanding and recollection of this was dealing with names.
Even though that is not on the written page here.
That is correct.
And so, as a result of this accident, you've had to undergo physical therapy, occupational therapy, speech therapy, and vestibular therapy, correct?
Yes.
And who was managing the bankruptcy while you were
I wasn't even going in.
Okay. My question is, who was managing the bankruptcy at that point?
I don't know. I don't recall.
You didn't go in for 6 weeks subsequent to your surgery, correct?
I think it was 4 to 6 weeks. I don't recall.
You testified 6
Yeah,
weeks.
yeah.
And so is it your testimony that you don't know who was managing the bankruptcy at that point?
That is correct.
Who would have been reviewing fee bills?
I don't recall at the time.
And you talked earlier about Excel spreadsheets, and you claimed in your deposition that you have trouble multitasking or even being able to review Excel spreadsheets as a result of this accident, correct?
Yeah, in discussing, it was nested VLOOKUP tables that I was struggling with, which is fairly complicated Excel routine.
You didn't say that, did you?
No, but that's what I meant.
All right. And so you're qualifying earlier testimony that you gave in a different case, correct?
I don't know what that legal term is, but that's what I meant when I answered that question specifically, because I remember it.
At that time, not only could you not create Excel spreadsheets, you couldn't look at them for more than 30 or 40 minutes, correct?
At which time?
When you gave your deposition.
No, I could look at Excel spreadsheets, but it would take me longer to manage through. Simple Excel spreadsheets, easy. More complicated, more difficult.
You never made that clarification in your deposition, did you?
No,
And isn't it true, sir, that you testified that you could only look at Excel spreadsheets for no more than 30 or 40 minutes?
I did.
Is reviewing attorney billing entries to you different than reviewing a spreadsheet?
Yes, because it's static data.
You had much more experience reviewing Excel spreadsheets prior to this bankruptcy than you had reviewing attorney's fee entries, correct?
Yes.
And you claimed in your deposition that you have to be home by 4 o'clock, didn't you?
Yes.
And you testified that you don't even take calls after 4 o'clock because you don't speak much toward the end of the day, correct?
That I have fatigue at the end of the day, that is correct.
What I just said is correct.
Yes.
Okay. Has that changed?
I try not to talk when I get home about business.
Okay, but that's not what you said.
Yeah, well, that's what I meant in the deposition.
But Archbishop Eagan will call you whenever he wants because he doesn't much care about your time, correct?
I disagree with that. He knows to call me before dinner time.
Look at volume 2, please. And go to page 22, please. And read to me, please, sir, lines 2 through 4.
He doesn't care much about what time it is. He'll call me anytime he wants.
That's all.
Okay.
And that's the opposite of what you just said, right? Because you said he knows to call me before dinner time.
Yes, but he usually calls me on Saturday and Sunday before 4 o'clock.
Well, that's not at all what you said in this deposition, is it?
But that's what I meant.
I see. And since you gave that testimony, you have been at the Chancery past 4 o'clock, haven't you?
Yes.
And you have been at bankruptcy court past 4 o'clock, haven't you?
Don't recall.
And you have been here at Jones Walker's offices past 4 o'clock, haven't you?
Occasionally.
And nowhere in your 3 car wreck depositions did you ever qualify that sometimes you work later than 4, did you?
I guess so.
So can we agree, and based on your honor code and what you believe, that lying or exaggerating under oath would be nefarious, maybe?
I would never intentionally lie under oath.
Not intentionally, right? So you testified earlier that you're a cost-conscious individual, correct?
Yes.
And you would agree that you have approached Jones Walker's legal fees far differently than you approach costs in your own personal life.
No, I would not agree with that.
Okay. Would you say that you've been super cheap in how you've dealt with Jones Walker?
I would say that I have been consistently discussing entries of all legal bills, albeit Jones Walker or anyone else.
You also complained repeatedly during your car accident deposition about the cost of the medical treatment for Dr. Thomas, didn't you?
Yes, sir.
And you even complained about the size of the house he's building, correct?
Correct.
So let's talk specifically about some of the physical and cognitive impairments that you claim to have sustained in this car accident. Obviously, you have significant neck problems, correct?
I had surgery to correct the neck problems.
Okay. But obviously, you still have physical impairment from your neck injuries, correct?
Yes, I earlier testified that there is inflammation at the bottom of the fusion.
You also have serious balance issues that you relate to this car accident, correct?
Correct.
You've fallen a few times because of these balance issues, correct?
I've fallen because of gabapentin and I forgot the name of the drug I take at night for muscle relaxing. But
Amitriptyline?
no, amitriptyline is not the muscle relaxer. It's if you have the list, I can tell you what it is, but starts with a T something.
You never testified, Mr. Eagan, did you, in any of your car accident depositions that you fall because of gabapentin, correct?
No, I didn't.
All right. And you fell down in Archbishop Amon's office, correct?
I did not fall down. I didn't fall to the ground, no, sir.
Okay, let's take a look at Volume 1. Page 71, please. And I would like you to read aloud lines 8 through 15.
Tell me how it would affect your normal day. It's when you stand up for a chair. I do a lot of things. The other day I was in the
Wait, you have to slow down, sir.
Oh, I'm sorry. Oh, I'm sorry.
Can you read slowly and clearly your answer beginning at page 11?
In every word, please.
Page 11.
I'm sorry, at line 11.
A lot. It could be a lot of things. The other day I was in the Archbishop's office and I was standing up and I just fell down. I just indicating my hands going to the ground.
Which is the opposite of what you just said, correct?
I did not fall to the ground. My hands caught me at the bottom.
At the bottom of what?
Yeah. Would you like me to show you?
No, sir.
Okay.
You can explain it to me, that would be fine.
Yeah, so I didn't fall flat on the ground. My hands, I think it might have been to the sofa, I can't recall.
Your balance issues have not improved since this accident, have they?
Actually, they have.
Between March and now?
Yeah, I wouldn't say appreciably, but enough.
You claim to have trouble just walking, correct?
Athletic walking, not just walking.
Okay.
So, walking 3 or 4 miles.
You didn't say that in your deposition, correct?
That was my intent.
You walk much more slowly than you used to, correct?
At the time of the deposition this deposition, that is correct.
And you veer off to the left while you're walking with your wife, correct?
Not anymore, but I used to, yes.
When did that stop?
Maybe 6 or 8 weeks ago.
Okay. You claim to have headaches as a result of this accident, don't you?
Oh, yes, sir.
And do you still have those headaches?
Not as often.
And those headaches had gotten so bad that you could not control them and didn't know what to do about them, correct?
That is correct.
The pain from your headaches was so bad that you stated to Dr. Happel you just couldn't do it anymore because of the pain, right?
That is correct.
And what did you mean when you said you couldn't do it anymore?
I don't recall the context of the discussion with Dr. Happel.
And you describe that headache pain as 9s and 10s out of 10, correct?
Prior to the surgery, yes, sir.
Certainly with that type of pain level, you're unable to function in any job, correct?
No, this mostly happened when fatigue set in at the end of the day.
And that's when you would have a 9 or 10 out of 10
That
headache.
is correct.
And certainly you couldn't function like you're doing now with a headache like that, correct?
That would be very difficult.
And even after having your neck surgery, you still rate your afternoon neck pain at a 7 to 8 out of 10, correct?
In certain times, that is correct. Different pain, though.
And you have dizziness that you attribute to this accident, correct?
It is not as bad as it used to be.
You have dizziness that you attribute to the
Yes.
accident, correct?
Mm-hmm.
You have fatigue that you didn't have before the accident, correct?
Yes.
All right. Would you describe yourself as being exhausted from the injuries you sustained in this accident?
I would say I'm fatigued at certain points of my life and days, yes. Fatigue.
You testified that you're exhausted, correct?
Yeah, so
Are you sometimes angry as a result of this accident?
I try not to be angry. I forgave the lady a long time ago. In my
When
mind.
did you forgive her?
Soon right after the accident.
Do you remember testifying in your deposition that
No,
you're still, you're not even letting me ask the question,
I'm sorry. Okay.
that you're still trying to forgive her?
I now forgive her.
Okay. And were you angry at the time of your deposition in March?
At what?
At this woman, at the accident, at the situation?
I would probably say that the deposition generates some emotions that I would rather not have had.
You would agree that sometimes your attention span is affected by the injuries you sustained in this accident?
That has improved significantly, but yes.
All right. So all of these things have significantly improved between March of this year and now, correct?
Yes.
You also testified that you have trouble sleeping as a result of your injuries, correct?
Yes.
And that hasn't improved since the accident, correct?
It has.
Okay. It had not improved as of March, correct?
Medicine helps me sleep when I have trouble sleeping.
You've testified that you can't stand up for long periods of time, right?
That has improved also.
That improved since March.
That has improved, yes.
And generally, you have more problems from your injuries after noon, correct?
Yes.
And you testified, did you not, that afternoon you're just, quote, taking balls and strikes, unquote, didn't you?
I might have said that, yes.
You did say it.
Okay.
And so that's different now?
Yes, I think I'm better in the afternoons than I used to be.
Okay. And so from October of 2022 until at least March of 2024, you were just taking balls and strikes in the afternoon, according to your own testimony, correct?
After the surgery, there was certainly improvement, but more improvement after the 6-month mark.
Did you testify that how much you do in the morning doesn't determine how bad your afternoon's going to be?
Yes.
And as we discussed before, generally it takes you longer to do stuff for the Archdiocese, but also for Magnolia than it did prior to the accident.
Yes.
And these things used to be very easy for you, but now they are very difficult, correct?
At the time of the deposition, correct.
But that's not true anymore.
It's improved.
And you've had problems using a computer since the accident, correct?
I go back to the complexity of certain Excel formulas is what I meant in that particular dialogue.
Okay, I want you to take a look at volume 2. Page 27. And I want you to read for yourself, or read to yourself rather, starting at line 22 of page 27 to line 2 of page 28.
Out loud?
Now read it to yourself.
Yes.
And that has nothing to do with Excel spreadsheets, right?
It has a fair amount to do with Excel spreadsheets if I do not rename them correctly.
What you said was one of your more difficult things is figuring out in which directory a file is,
Yeah,
correct?
so an Excel file, that is correct.
You didn't say an Excel file.
That's what I meant.
And that's extremely frustrating for you, correct?
Yes.
So you testified in your deposition that the medication that has the adverse effect on you is Nurtec?
Nurtec's a headache medicine, so. What page are you on? I'm sorry.
I am on volume 2, page 62.
Now, Nurtec he tried to put on for the headaches.
And so tizanidine is what you were referring to earlier, correct?
Tizanidine. I'm sorry,
You don't remember?
I don't remember what tizanidine is.
Okay. It's a muscle relaxer,
Trizan, is it a T or a D? I'm sorry.
T-I-Z-A.
Yeah, that's the one I talked about at night. That's correct.
And you said that you can't function after you take that, correct?
Yeah, I only take it right before I go to bed.
Earlier, you testified that in your volunteer role with the Archdiocese, you treat this role the same as if you were employed by the Archdiocese or if it was your own business. Do you recall that?
Yes.
I want you to take a look at volume 2 at page 81. And if you read from line 2 on page 81 to line 15,
I'm sorry, what lines?
lines 2 through 15,
Okay.
so clearly you do view this role differently than when you had your own business, correct?
I always like to do things to the best of my ability, whether it's my business or whether it's this or whether it's Magnolia.
That's not what that testimony says.
That's my answer.
Sir, that's not what that testimony says, is it? It essentially says you're not staying up at night worrying about what happened at work today or tomorrow or the next day. Correct?
Correct.
And you say, but it's not like when I had my own business, correct?
Yeah, because I'm not worried about, no one reports to me, I don't have employees, that's the difference that I make there.
And in your automobile accident case, you have what's called a life care plan, correct?
Yes,
And that is for all of the impairments that you're going to have and medical treatment into the future, correct?
so what it's supposed to be, yes.
All right. And in your deposition, isn't it true that you testified, I'm tired of not getting better?
Yes,
And so, is it fair to say that the entire period of time that you were working for the Archdiocese between October of 2022 and March of 2024, you weren't getting better?
the operation, the fusion, changed the manner with which the pain presented itself. But it was not improving my overall quality of life.
And you want the car accident case out of your brain so you can focus on getting better, correct?
That's true, yes.
And you said that, correct?
Yeah, I'm sure I did.
And yet you testified that you preferred giving a deposition in that case to attending mediation in this case, correct?
Correct.
And so logically, you would admit that your role in this bankruptcy prevents you from focusing on getting better, correct?
No, I do not agree with that.
The car accident litigation does, this doesn't, correct?
Rephrase your question, please.
Sure. You testified that you want to get that car accident litigation out of your brain so you can focus on getting better. And what you're telling me is that even though you preferred being at a car accident deposition as opposed to a mediation for the Archdiocese, it doesn't affect you the same way, correct?
The automobile accident was a very personal experience and a near-death experience, so it's different.
And you have put exponentially more time into this bankruptcy than you put into your car accident case, correct?
I don't understand that question.
Well, you said earlier, or agreed with me, that you may have put 6,000 hours. So you put, and let's talk about from the period that you got in the automobile accident, you would agree with me that you put exponentially more time into this bankruptcy than you do into your car accident lawsuit.
Yeah, because there's not much for me to do in the car accident lawsuit.
And you have settled part of that for over $1 million, correct?
I haven't seen a check, no, sir. I have settled, I have not signed a document, and I haven't seen a document.
You settled for $1.15 million, correct?
That is correct.
And you are still seeking more money from your underinsured motorist carrier, correct?
Correct.
And you have a trial date where you're seeking to get more money, correct?
Correct.
Wouldn't you agree, Mr. Eagan, that victims of child sexual abuse deserve at least as much money as you've gotten for a neck injury?
Object to the form of the question. Calls for a legal conclusion. Don't answer that.
Okay, give me a 5-minute break if you would. I think I'm close to wrapping up.
Sure.
We're now off the record, times 3:40. We're now back on record, times 3:31.
I don't have a whole lot more for you, Mr. Eagan, so we'll be done relatively soon. I just want to clean up some of the stuff we talked about earlier. Do you have any cognitive decline that you don't relate to gabapentin?
I would say just memory, name recall for a 72-year-old guy is just typical, but other than that, no.
And so as a volunteer for the Archdiocese, you would agree with me that you have no direct employees that report to you?
Correct.
You have no secretary?
No,
You have no assistant?
no.
You have no personal budget for your activities?
I don't spend any money.
All right. Do you have a computer at the
My
Archdiocese?
personal computer,
Laptop?
the Surface.
Do you have expense reimbursement?
I've never, only once did I put in for expense reimbursement when I flew to DC. Other than that, I pay all my expenses.
What was the DC trip for?
To speak to an insurance company.
All right. Do you have check writing authority?
No.
Prior to today, did the Jones Walker lawyers know that you had given a deposition in your auto accident case?
I think so. I think so.
Did you give them a copy of it?
No.
Did Archbishop Eagan know?
That I gave a deposition?
Yes.
I'm not sure I remember telling him.
And so the final question, barring one or two follow-ups, according to your testimony in the car accident case, the litigation, you just want to be done with it, correct?
Yes, sir.
And you understand that all of these child sexual abuse survivors want that more than anything.
Yes.
All right, I appreciate your time.
Thank you.
All right.
I
See
didn't
you-
introduce myself. Are we still
See
on
you in the
line?
morning. Okay.
This concludes today's deposition. We're now off the record. The time is 3:34.